Good, good, good.
Great.
It's good to be here.
You.
Thank you very much. No, it's good to be here. I always like these opportunities to interact with our registrants.
Awesome. So over to you, Timmy.
Well, thank you very much. Guys, I was asked to present here today. Let me just get my screen going. All right. Thanks, everybody. Thanks for taking the time this morning to join us. I was asked to present this webinar today on this platform, and it falls under the banner of the NCR Educational Webinar Series. Credit provider terminations under the National Credit Act, and there's a few issues that we are going to be tackling today. Topics for discussion is why this webinar. I think it's important that you just be put into the loop. How far we've come. I'm going to take you back a little bit in time to look at consumer credit in the olden days, and then we'll look at some modern consumer credit, modern credit provider thong and feta, modern debt counselling response, and then a short conclusion. Now, why this webinar? This was a CIF Accredited Industry Forum agenda item that was brought by DECASA, and it informed the Credit Industry Forum that there is a general misconception within the industry surrounding terminations, when can accounts be terminated, and that credit providers terminate when matters are already set down for hearing. So that's why we felt it important that this webinar be held. It's both from a debt counsellor and a credit provider point of view. It's important to keep that in mind. And even though the task team agreements clearly state a whole bunch of sections surrounding terminations, there's not going to be enough time in this webinar to deal with the task team agreements and the impact thereof on 8610 and 883 and so on. So use that as some extra reading. If you are confused, pop us an email and we'll guide you further. We also touched briefly on the NCA and the amendments thereto. The 2019 amendment is not included, and because it hasn't assented to law yet. And it's done on the consumer friend platform, as it is a much larger platform than the NCR currently have. And that during the CIF discussions surrounding this webinar, that consumer friend was so nice to give us the opportunity to use this much larger platform for us to reach a much wider audience than we would normally do. Now, I think to give some context to the discussions we have today, I want to take you back some 2,500 years to consumer credit as it was in 450 BC, when the Legge, Della 12, those are the 12 Roman law tables, were published as you like, where it was chiseled out of stone, and these were the laws of the time, and it dealt with various issues: trade and commerce, family law, adoptions, consumer credit, and so on and so on. And it was very important at the time because the plebeians said, yeah, but you know what, the law applicable to the royals and the law applicable to us are not the same. We want to know what these laws are, so that there can be equal treatment of the plebeians and the royalty under the law. So the commissioners, the decemvirs, proclaimed the common law at the instance of the plebeians by molding the brass and stone and erecting these at markets and forums for everybody to see. It caused a breakthrough in human rights as we know it today. In that everybody now can get treatment under the law, everybody can look at the law, everybody can interpret the law. And it's not only the very educated people with the black gowns that can now interpret the law and put arguments forward. And it set the common law for millennia. Some of those tables are actually still applicable today in some form or another. Now, you will ask yourself, why is this important to know? And I think when you see where we're going with this, you'll see why this is so important to remember when we look at modern consumer credit today.
Sorry, Tim.
Yes.
Tim, can I just stop you for a second? I think I've got Zoc that says he can't hear you. I'm not sure if everybody's having the same issue. Can you guys put it on the chat if you can hear Tim or not? Okay, Zach, I think it's just you because the others can hear loud and clear. Just check on your side. Okay, sorry about that, Tim. You can carry on.
No, not at all. Not at all.
Okay.
Zach, I hope you can get it sorted, because you always join our webinars and it's always nice to have you. So the Legge Della 3, so that's the third Roman law tablet, dealt with consumer credit. Now, it was very strange that it is very much in line in some instances with the laws we have today. And what Table 3 said, and you're very welcome to go Google it and read it. I'm sure you'll have a good chuckle on how far we've come in the last 2,500 years. So, in your judgment shall be paid in 30 days. So that was how the table starts. So any judgment that was given from a court shall be paid by a consumer within 30 days. If the consumer do not pay it, or the debtor do not pay it, then the debtor shall be bound by the credit provider with thong and with fetters, weighing no less than 15 pounds or more if the credit provider, and I'm going to call it that for the purposes of this webinar, so wishes. So the weight could increase from 15 pounds to whatever. If a debtor cannot afford his own bread during this time that they are under thong and fetter by the credit provider, the creditor shall provide a pound of bread a day to the consumer or the debtor, or it can give them more bread if it likes. So then, unless payment arrangements is made, the debtor shall be held in this bondage for 60 days under the thong and fetter for a committal period of the non-payment of the debt. The consumer had to be brought back to the comitia for further appraisal. So that's at a market where a committee would sit and then hear what has happened in the last 30 days and see if further arrangements can be made. So and also just keep in mind, this is very loosely translated from Roman, from Latin. We're from the old guard that still had the Roman law at university level in Latin, and the textbook wasn't translated at the time. So, we loosely translate these things as we have the skill in Latin and as it gone along. Now, you might then ask, what is a thong and fetters? Now, I found one example on the internet of a thong and fetter. Now, this would be a more modern type of thong and fetter. The thong refers to the rope that is tied to both the hips and the feet, and the fetter is that lever that the guy on the left and the right are holding and rolling up the rope to a strength of 15 pounds, which is referred to earlier, or more. So that would then be tightened. It could be out in the open, as this is out on a platform. And just imagine a debtor being subjected to this for 60 days where the debt has not been paid. In addition, as I stated earlier, it brought equality and it brought freedom under law, because if a prince of the empire or a royal person could not pay debt for any sort of reason, they would then also be subjected to this type of treatment under the law. So modern consumer credit, let's superimpose some modern consumer credit on here. Are our consumers not stressed today as being under thong and fetter, even if it's not in terms of a law? Look at the suicides that has been reported recently because of consumers being credit stressed. Let's look at the broken families, especially where a bond is foreclosed and a family lose their homes. Those normally turns out into broken families. COVID, I'm not even going to get into that. Current unemployment, especially in our country, and just general hardship. That when we switch on the television, we see the general hardship under which our population is currently, and what they are trying to do to get out of it. If you also look at recent publications by the NCR relating to 17.3 change of circumstances, the annual review work that we're currently doing at subcommittee level, is all to do with our consumers that are so stressed, and our consumers that's currently still being under thong and fetter. But then, as I stated in the introduction, we need to look at it from both sides, also from a credit provider side, because a credit provider is there to loan money and to get the money back. That is their business model. And are our credit providers not stressed today, not having a thong and fetter as they had at that time? As you can imagine, with these type of laws in place, default levels, I think, would have been very low, because if you knew what was waiting for you as a debtor, you would first be very, very clever in going into credit once you understand that you can pay it back, and then making sure that no default occurs under your credit agreements. But alas, the credit providers still do have a thong and fetter under the National Credit Act. It's Section 129, which we're not going to discuss here today. I think that the law and everything surrounding Section 129 has settled down, and it is used productively by credit providers in litigation and otherwise in our courts. So Section 8610, that is, we all know that, where credit providers can terminate. We'll get into that in a minute. Section 8611, which is a stay of execution, if you like. And then Section 88.3, which is post-termination actions that a credit provider can take. Let's look at Section 8610 of the NCA. It's been a rocky road for 8610 over the years. In 2010, the task team agreement dealt quite extensively with explaining 8610 and giving context and meat to what was in the Act. It was very contentious at the time. There was a lot of case law surrounding that. And the 2010 task team agreement, tried to give some context and assist all the registrants, both debt counsellors, consumers, and credit providers, in dealing with Section 8610 correctly. Then in 2011, the Supreme Court of Appeal judgment of Legge came out and just upset the apple cart, whereby it says that credit providers can terminate even if a matter has been set down for court. I recall I was in the industry at the time, and it really upset the apple cart, and it caused a lot of confusion within the industry. And then the 2014, the Amendment Act that came into being, I think the 13th of March 2015, had a further amendment and a further addition to 8610, which we'll be getting into now. So it's been a rocky road for 8610. It's been under the spotlight quite a bit, and for very good reason. And let's go into that reason. So Section 8610 says where there's a default under a credit agreement, even a credit agreement currently under debt review, the credit provider may terminate. Now, I think if we just put in participation, within the wording of the law, may terminate participation in debt review, it is much easier to understand. The credit provider from 17.1 onwards participates in the process by giving a COB, by looking at the proposals and giving acceptances or counters or whatever the case might be. So they are an active participant within the debt review process. And when they terminate, what they are in fact stating is that we are no longer participating within the debt review for whatever the reasons might be. And they terminate their participation in the debt review process by giving notice to the consumer, to the debt counsellor and the national credit regulator, that has, or this section of it has also been subject of many case law. You know, when it would be sent, how it would be sent, how it must be proven. I remember, you know, in 2011, 12, 13, the courts were not lenient on the delivery of this notification, and there had to be registered slips and all sorts of things that had to be produced at court prior to a court hearing any enforcement actions. So I'm not going to get into that. You can just Google it, and I'm sure you'll find a lot of case law on this issue. So then came along Section 8610B of the National Credit Act, and that was contained in Section 26 of the 2014 Credit Amendment Act. You can just find it on the internet, and it established a prohibition on the termination. Now, that would presumably be in response to the Legge judgment of 2011 to set right, you know, the upset of the apple cart that Legge caused in 2011. And what does it say? It says that a credit provider cannot terminate if an application for debt review is filed at court or at the NCT. And it really set the record straight as to, you know, the power of the matter setting down, giving context to the issue of the 60 days. And I think just in general, settling, you know, the rocky road that 8610 has run over time. Now, this implies even when the consumer is in default that a credit agreement cannot be terminated, or that, as I stated before, a credit provider cannot terminate its participation in the debt review process. So I think just important to note, filed, the word filed under the Magistrates Court Act means that application is both served on all the parties involved within that litigation or application, and that it is filed at court or at the National Consumer Tribunal. Now, this immediately implies that there would be a case number on the document. There would be a court stamp on the document. There would be a date of hearing on the document, and that the document would be ready for a hearing at court or for litigation as we know it. So the inclusion of Section 8610B is very important. And I think that this was a very large discussion, or a big part of the discussion at CIF, where it was indicated by the CASA that credit providers still terminate even where applications has been served and filed. And I don't understand why there is still confusion surrounding credit providers and Section 8610B. So, you know, where you have issues like this, you just quote the Act and see where you go from there. And I don't think that there's any grey areas today surrounding this issue. In Section 8611 of the NCA, also a rocky road, but not as much as 8610. Also affected by the amendment of 2014, and it's a post-termination get-out-of-jail card that is offered to consumers and debt counsellors where there has been a default. But this get-out-of-jail is unfortunately not for free. You will remember that this is enforcement action that has already been taken. So this is a credit provider that has already terminated its participation in debt review, as an example, and has proceeded to enforce their rights under the credit agreement by foreclosing on a home or whatever the case might be. So now we're in a court. We have attorneys' fees in it. It's normally in the High Court, you know, when we deal with issues such as bonds or cars. So we have advocates' fees, we have attorney fees, we have legal fees, and these bills, especially when you get to a summary judgment stage where you have to oppose these type of applications, normally at summary judgment, where you request a referral back, the consumer is already strained, you know, even long before enforcement action has been undertaken by credit providers. And the money used to oppose enforcement could have been used to pay the debt. And I've seen I've seen a lot of tax bills of costs, at summary judgment stage that exceeds 20,000, much more than 20,000 in some instances. It depends on how long the argument was. And it is really very counterproductive to wait until you get to this stage, to deal with the consumer issues surrounding debt or debt enforcement. So I think the lesson here, taking it all into consideration, is ensure that 8610B protection is there for the consumer. Section 88.3 of the NCA is post-court order termination. There's a misconception among debt counsellors in general that notice needs to be given in terms of 88.3 for enforcement action to take place. Just to go back, this is specifically where a judgment has been granted and there is default of the consumer under that court order. Now, the fairest judgment from the Constitutional Court states very clearly that the credit provider do not have to give notice of its termination and participation in the jury process after a judgment where there are default. And I think that's settled everything. And I think it was a 2016 judgment, if I recall. And that settled it around. Now, a lot of debt counsellors, also in anticipation of this webinar, indicated to me that, yes, credit providers do still send out 88.3 notices, and they don't know why they're wasting their time and their money. In discussions with credit providers, it was stated that, you know what, we do it in terms of good faith. We're showing good faith in the process. And it's a courtesy to say to the debt counsel, listen, there's been defaults, expect that something now is going to start to happen. So I think the takeaway from all of this is that avoid defaults under court orders, specifically under court orders. And it is very, very important for debt counsellors to ensure that the proposal that is put forward by them pave the way for the consumer to be able to pay in terms of the court order. You know, where budgets are cut and it's cut to the bone, and the smallest little thing happen, a child gets sick or whatever the case might be, the alternator of the car breaks, you know, then you sit with a defaulting consumer with a court order, and then you sit with a problem. So I think end to end, debt counsellors need to be very, very, very careful to ensure that consumers have sufficient money available to deal with, special emergencies. The task team agreement deals very specifically with that under contingency issues. So debt counsellors need to ensure that they do their job properly right from the start to avoid all these unpleasantness, additional work for everybody and additional costs for everybody. That comes with 88.3, 86.10, and 86.11. So it should be avoided. Now, the modern debt counselling response. Now, imagine what a noble profession and career debt counselling would have been 2,500 years ago. I think any defaulting consumer would even before default would be at the door of the debt counsellor to make sure that the debt counsellor will stop them from hanging on that thong and fetter and be pulled for 60 days. That's amazing, that 60 days is also within the National Credit Act. I'm sure that it is coincidental, but it's just strange that you see that. And I think even today it did not change. With the consumers being under thong and fetter as it is now regarding, the general economic conditions and so on and so on, debt counselling is still a noble career. Debt counselling still gives hope to those consumers that are stressed, those consumers that would look at suicide, when it comes to the stress of credit, that's going through general hardship. And I've seen a lot of success stories, where consumers were at that point in their lives. And with good counselling and with really good protection given by the debt counsellors, that they have passed through that, they've gone successfully through that, and their marriages are stronger for it. Their kids are still at home and at school, and that they are generally much better off than they were during that time when they were debt stressed. So the debt counsellors have the tools, to assist consumers and making sure that debt counselling still remains a noble career and provides the necessary protection for consumers, during the time of the need. So I think consumers need to be protected. The debt counsellors have to have the protection of the consumers at heart, right from the start, dealing with the process in general, and educate the consumers on the process. Make sure that the consumers know what they're getting into. We recently had a set of webinars regarding the withdrawal process, and it was recommended that consumers be given a copy of the withdrawal process, and that they sign it so that the debt counsellor have proof that they have discussed it. And it's a very topical thing at this time, where consumers do not know that they can't withdraw from debt review under certain circumstances. So just in conclusion, I think it is very important that the debt counsellors remember where we come from. And I think that was a big part of me taking you back so far today, is to remind you where consumer credit comes from, and superimposing it on the situation today, what our consumers are going through. And for most of them, you are the only hope. You are the only people that can protect them from credit providers. Maybe not as unscrupulous as it was 2,500 years ago, but still, when it comes to the consequences of default and the consequences of terminations of participation from debt review, that stress is still on the consumers, and that is your responsibility, to protect them and use the tools. Thank you. That's all from me. I didn't want to keep you up too busy, and I wanted to have some time to take some questions from you if there are any. Thanks, Tricia. Back to you.
All right. Thank you so much, Tim. So I think the consequences are far greater when you receive a Section 8610 and an 88.3 than remaining under debt review and actually paying the reduced installment and interest. I know that consumers have saved between 50 and 80,000 Rand in interest and fees. Also very interesting to note that despite the debt review applications declining last year due to the pandemic, DC's actually collected over 10 billion Rand that was paid over to the credit providers. So well done to you, the debt counsellors, and continue to get your clients to actually make that monthly debt review payments so they can benefit from this reduced installments and interest rates. All right, so Tim, let's look at some questions that was posed in the chat. So the first one is from Willem van Hayden. Why is the collect judgment ignored, whereby the credit provider may not terminate if consumers was not in default prior to applying for debt review? Tim, can you hear me? Tim, I can't hear you. I think you're muted.
Sorry, just say that again. You were breaking up a bit.
Okay, so I was saying that the question from Willem, why is the collect judgment ignored, whereby the credit provider may not terminate if consumer was not in default prior to applying for debt review?
I don't think it was ignored. I think the collect judgment says that if there was default and a application was already filed at court, that the credit provider can terminate. So I think it was the other way around. I think default is the most important part, and I think default is what triggers everything. Now, I recall during 2011 when the collect judgment came out, that it really caused confusion within the industry. The debt counsel was saying, we're getting to court in 60 days, and now we're punished for it. With the 2 months that the consumers are paying the debt counselling fee and the legal fee, it would cause automatic default. So what does 8610 really mean then? What does 8611 really mean? What does debt counselling really mean? Because we're doing all this work. There is going to be default anyway, and now they can terminate their participation and proceed as if debt counselling wasn't there. So you know, it caused much more stress than it would normally have done. And I see my dog in the background here. Oh my goodness, sorry.
That's okay.
So yeah, I think Willem, it's just the other way around. You know, it could have been much worse if the 2015 amendment or 2014 amendment wasn't there.
Thank you so much, Tim. All right, so Anonymous asks, consumers married in community of property applied for debt review and did not proceed to court order and thus terminated in terms of Section 8610 by all credit providers. Consumer then divorced a year later. One of the spouses applied then for debt review a year after the divorce. Would this be a new application as they have since divorced?
I don't think it's as complex as that. When you get divorced and when you have a good attorney, which unfortunately we don't see a lot these days, the settlement agreement in which the parties would you know, part ways would be very clear on the issues of the split. So you would typically find that there would be arrangements surrounding the kids. There would be arrangements surrounding the maintenance. There would be arrangements surrounding the splitting of the assets. You know, very specific if there's a house, if there's a vehicle. And if you have a good attorney and a forward-looking attorney, you would have an issue surrounding or a settlement on the debt. So a lot of these agreements, especially in the regional courts that you see, would state that each party would retain the debt for which they applied. Or the person or the party staying in the house will pay the bond, or the party that takes the car will pay the car. You know, so the settlement agreement should be the biggest guide for a debt counsellor when looking at divorce issues. And, you know, if it's not there, then it starts getting a bit tricky. And we see that from time to time. But if it's there, just follow the settlement agreement. There is a process within Debt Help to split the two consumers, you know, where there is a divorce order. So you would then typically send to the DHS team a copy of the divorce order and the settlement agreement, and they will guide you into the splitting of the application into two individual units, especially you know, if there's a court order granted, because the divorce order would not set aside the debt review order. I mean, you would not have that. So they would still be both be under court order. But no, it would not be a new application, because in DHS it will split. The one would then pay off all its debt in terms of the settlement, hopefully if there was one, and then a clearance certificate would be issued if all that consumer debt has been paid. So no, it wouldn't be a new application; it would just be a split. In
all
DHS.
right, perfect. Thanks, Tim. All right, Kipio asks, can a Section 8611 be used in an initial application to court for a debt review court order if a termination has been received prior to set down?
That's a good question. Remember, all credit agreements that is subject to any enforcement action would be excluded from the debt review process. So you would typically, you know, where enforcement action has started, and you know, if you're talking about 8610, you're talking enforcement action. I mean, it goes hand in hand. That would be excluded from the process right from the start. It would be included as an expense in the consumer's income and expenses, and there would be a separate arrangement outside of debt review with regards to that. There would not be any other instance that I can think of that 8611 would come into play, you know, during the debt review process in itself, you know, unless it's an extended process outside of the 60 days. So enforcement action would exclude it straight away unless you can negotiate with the credit provider on behalf of the consumer for it to be put into debt review.
All right. Leanne asks, so if a CP terminates and the client wants a clearance certificate, what happens to that agreement? Do we exclude it and proceed for clearance? And will this be acceptable to have their name cleared?
This is a huge discussion that we had at the withdrawal guidelines subcommittee, where there could not be, where we could not find consensus between credit providers and debt counsellors surrounding this issue. I think what we did agree upon is that a termination does not cause a consumer to exit debt review. You can't draw that distinction. It's a bridge too far. And section 72A, was it 71A, I can't recall, states that where a credit provider has terminated its participation in the debt review process, the responsibility is upon them to, once that debt has been paid off, to then take that off from the credit bureau. In opposition to that, where there were no default, and the payments have been made by the consumer, then the clearance can be issued, and it's then the debt counsellor's responsibility to inform the credit bureaus of the removal. So that is a contentious issue, especially where all the credit agreements have been terminated. What do we do then? We need to wait for it to be paid and for the credit provider then to remove it from the credit bureaus. I think practically, it makes no difference. You remain on the credit bureau as in default until such time as all the debt has been paid either way. It's just a process that would be different. So there is no real answer to that question, but the consumer will remain under debt review until all the debt is paid.
Thank you, Tim. All right. Susan asked, credit providers terminating under Section 88.3 prior to the granting of the order due to default. This could be due to unforeseen circumstances that the consumer has defaulted on one payment, for example. In many cases, then the application will be opposed. Could you please clarify?
88.3 deals specifically where an order has been granted. So it is a prerequisite for 88.3 to become applicable that an order is granted and there's a default under that order. Now, I don't know how 88.3 termination can be done prior to a court order. That would be 86.10 in terms of default or the passing of 60 days. I don't think there would ever be such an application. Where you would oppose such an application is in an enforcement court, because 88.3, like I said, they would not require a notice. So what will the debt counsellor and the consumer get next? A summons for enforcement in the High Court, and that enforcement would be fought not by 88.3, but it will be fought in terms of 86.10. So I cannot see a scenario where that would be applicable.
Yeah. Right. Yolene asked, can a credit provider terminate if they counter and we show that the client cannot afford? As sometimes a creditor wants more than the living expenses that is left on the budget. So can the credit providers terminate in that instance on a counter?
Remember, 86.10 does not talk about interaction between the parties. It does not. It talks about default, and it talks about the passage of time. So my first question would be, why is this not a DCRS proposal? DCRS is extremely important because these are rules that everybody agreed upon, credit providers and debt counsellors. It depends on from which side you're looking at it, would be acceptable. And where a DCRS proposal has been run and the interest has been reduced and the term extended, there should not be any sort of discussion surrounding that. We know that debt counselling is not the answer for everybody, unfortunately. And where a consumer is cut to the bone and have R2 left at the end of the month, after everything is paid, after minimum living expenses is paid, this is probably not the exit for a consumer under its current circumstances. So I would start, and I will go back right to the beginning, where the documents were collected, the consultation was held with the consumer in terms of Regulation 24. Was the job done properly? And if you get to a counter proposal stage and find out that the consumer cannot afford it, I think you're not doing your job properly.
No, definitely. All right. Anonymous asks, if a credit provider sends a termination notice to the consumer and not to the debt counselor on record, is this termination valid?
I would say no, because, and that is a big thing with the credit providers, you know, especially where the debt counselor has lapsed or the debt counselor passed away. You know, we have, unfortunately, 7 colleagues, debt counselors that has passed away of COVID that I know of, which is extremely sad, you know, dealing with the families and dealing with the staff and so on. But, you know, I'm not too sure.
Right. Anonymous, even when accounts are terminated in debt review, they must be included in the Form 19. Creditors, however, refuse to provide a paid-up letter for a terminated account, and the client often can't get it either. Shouldn't credit providers provide it regardless of termination?
I think that's why you know, I stated in my presentation that they terminate their participation within the debt review process. So what they tell the debt counsellor is, I'm not participating with you anymore. You know, we are now outside of debt review, and the rules of debt review, dealing with you in good faith and all those nice things, are no longer applicable to me as a credit provider. As I have terminated my participation, I do not have to participate with you anymore. And that is the thinking behind it. Because I'm not participating under debt review, I do not need.
Tim, are you there? Sorry, guys, I think we just got a connectivity issue with Tim. I'm sure he'll get back on now.
Trisha, I can confirm it is on Tim's side.
Okay. Okay, guys, so just we'll give him a few seconds to log back on. Hi, Tim, you back?
Yeah, load shedding.
Yeah, we all faced with that, eh?
It took my UPS just a few minutes to connect. Sorry about that, guys. There's nothing.
No, it wasn't too long. Yeah, Eskom to blame for that. All right.
I'm sorry,
yes.
Where were we?
We were on the last question. Yeah. So we were talking about including if clients, no, I also can't remember. All right. We were talking about if when accounts are terminated under debt review, they must be included in the Form 19. So we're talking about when accounts are terminated, do we actually get a clearance for those terminated accounts when we issue a Form 19?
A Form 19 would imply that all the debts have been paid. So, you know, if the debt has been paid, even if the credit provider under 72B or 71B, I can't recall, then inform the credit bureaus that the account has been paid. You know, there is no real difference. But if the account is not settled in full, it would immediately imply that it has no space on a Form 19.
Yeah, it has to be settled in full. We have to have that paid up letter, and then we can issue the Form 19.
Correct.
Okay. Okay. So I have a client whose matter was granted or court order granted. He's been unwell for over a month due to COVID. His company did not pay him as the company policy, no work, no pay. And he's obviously at home, and now they need to terminate as he missed payment. Would this be valid, or how can this, how can we assist this consumer?
Well, I immediately ask, why isn't the 17.3 process followed? We've worked very hard on 17.3, and in fact, 17.3 was not prepared because of COVID, strangely enough. It was worked on, I think, a year or even more before COVID came. And it was just extremely coincidental. And I think God's way of trying to assist consumers for us to get that 17.3 published, during the worst COVID times. So, my question would straight away be, why isn't the 17.3 process followed? I've really, looked, and I get copied in a lot of things, from time to time. And I've seen the credit provider responses to the 17.3. I've discussed the 17.3 responses to them. Irrespective if it's in law or not, a lot of things are not in law. Your debt counselling fees are not in law, but you charge it. So it's amazing that people will follow the one guideline, but will not follow the other. Absolutely.
Yeah.
But anyway, but that would be my first question. Was that process followed? And where there are sufficient reason, we know in these days it's not the consumer's fault. But you cannot have a credit provider lying in limbo and charging interest on an account forever and a day. I mean, they are entitled to the repayment of their debt. That is the basis of credit law. And at some stage, the credit provider is going to say, but you know what, where do you want me to go? What do you want me to do? So yeah, it's unfortunate that it happens, but default is the trigger, and when they are default, then you are now in the hands of a credit provider, and their policy surrounding the collection of debt.
Yes. All right. Another anonymous attendee: if a client was with another debt counselor before the current DC and the account was terminated with them, can the creditor refuse to reinstate the account with the new DC?
There's no reinstatement in the Act. You're not going to find a section that say that if the debt counsellor do 1, 2, 3, 4, it can be reinstated. When the default is cured, when the default is brought up to date, is there a default then that stands in the way of reinstatement? I don't know. You can have that discussion with the credit provider, and I would not think that it would be productive if a default has been brought back to exclude an account, or have any sort of discussion surrounding that. If it is, you need to interrogate. What is it the credit provider is looking at? Are they foreseeing for the defaults? There would be some other considerations surrounding that. Excuse me.
Okay. Zark King asks, can a credit provider terminate 8610 if no responses or acceptance received by the DC on a CP's counter within 5 days?
No, I don't see anything in the Act that would do that. I think the issue of counters and the acceptances and the negotiations surrounding that and so on and so on, stems from the task team agreement. That's where the real practicalities of it, was discussed and rolled out. You will not find that in the Act, and a counter is really the credit provider's way of saying, you know what, I'm trying to accommodate you. Your proposal for some reason or the other is not in line with our policy of collection. And the counter is an indication to you as to what we will accept. So no, Zach, I don't see that happening.
Zach also made a comment that he feels that the 8610B makes people go nuts for 60 days for some reason. Yeah.
I was the legal manager at quite a big firm And my KPA was this: get matters to court in 60 days. That was it. That was my KPA, and that was what I was judged on every single year of the 7 years that I was there. So yeah, going nuts is good. Going nuts is good.
Thank you so much for that. Okay, let's just see what else we have here. I'm looking at, there's a lot of questions that's out of termination, so I'm just reading the termination. So a notice of termination is only a notice of something that might happen in the future. If there is no summons issued, legal action has not started. That's a reference to the case law Nedbank versus Della from Renee Marius.
Yeah, no, it's a notice of consequence. That is exactly what it is. And if you look at the at Colette and the argument in a whole bunch of other cases, it is a notice of a consequence because of your default. I fully agree, because it's not automatic that a summons would then run and serve itself. There is consequence management that then would follow by issuing of a summons, serving of a summons, if it's opposed, setting down a summary judgment and getting judgment execute, foreclose, and so I absolutely agree.
Okay, perfect. All right, guys. So I think there is a lot more questions which we will come through or go through them. Tim, I'd send you some of the questions and we can answer it after this webinar because there's too much to go through. But I just want to say thank you so much for attending. You've been absolutely great. This is definitely a webinar that we needed. So thank you, Tim. Thank you to all our debt counselors for joining us this morning. I just want to say, stay safe, take care, and God bless until the next time we meet again. Thank you so much. Thanks, Tim.
Thank you so much. And thank you so much for giving us this platform on behalf of the Credit Industry Forum. I really appreciate it.
Excellent. Have a great day further, guys. Take care.
You too.
Bye.
Bye-bye.
Bye, Tim.
Bye.